Overwhelmingly, you've heard a lot of circumstantial evidence, some of which has gone uncontradicted, particularly with regard to the science. We've seen a lot of science evidence come forth through testimony, diagrams, pictures, without contradiction, tying up certain facts, including whether Mr. Welling was at the scene. It's going to be for you to decide, however, if there's circumstantial evidence enough to show an intent to commit a crime. It's the defendant's position that there is not, and he'll be asking for a vote of not guilty because of the state's failure to prove intent and knowledge beyond a reasonable doubt. I have to anticipate rebuttal because the state's attorney is going to have an opportunity to reply to what I'm saying here, as is their right. It's their burden. It's an enormous burden, and they've taken it on with their own responsibilities. In so doing, I have to concede that there's evidence that has gone without refute that Mr. Welling was at the scene. What you're going to have to do is determine whether or not in the state's argument and in the rebuttal they've shown you enough to prove an intent to commit the crime as alleged. I expect the judge is going to go through the instructions of the crimes with you as the state has shown you some of them. Those instructions are going to be as pertaining to all 5 counts, including first-degree murder, wherein the state is alleging that Mr. Welling has killed Mr. Daniels. The question is whether or not he intended to do so. The state has submitted that that's based upon location of body, the weapon, and the force. However, you have no direct evidence of what exactly was the defendant's intent or what was on his mind. They may argue that the defendant said something to Mr. McAllister that night prior to allegedly going to the scene of the crime. Bear in mind, Mr. McAllister's good friend James Prather stated that Mr. McAllister was under the influence of alcohol that night. You're allowed to take into consideration McAllister's statement of "I'm going to break in your house and kill you," and determine whether or not it's reliable based upon his consumption and overconsumption and the abuse of alcohol that night. Does that prove up enough intent? It's the defendant's position that it does not. The next count you'll be dealing with is whether or not there was an intent to do great bodily harm. The defendant submits this is along the same lines as the intent to kill. I'm going to ask your deliberation to that fact. Next is whether or not the defendant knew that such acts would cause his death. We don't know what was in the defendant's mind. Didn't state that entirely on his statement to the police. Next, whether or not his acts created a strong probability of death. Again, we don't know what was on the defendant's mind. Finally, the state's alleged home invasion, murder with home invasion, and home invasion. We'll address home invasion because it takes care of the murder on its own. Home invasion, there has to be proof that the defendant entered the Daniels residence without authority. There's no evidence, in fact, there is evidence of no breaking in. There's no evidence to suggest that there's a forced entry. Furthermore, you'll be instructed that the defendant would have to have known that somebody was home. In this case, Mr. Daniels. There's been no evidence produced to that effect. Consequently, the murder charge based upon home invasion would fall with the home invasion count.